with the proceedings. I'm sorry.
Okay.
Mama, do you have a question?
Yes, Ms. Oko, I can hear you.
My Lord, our motion is dated the 5th June 2025 and the 13th of June 2025 and subject to the competence of the Honorable Court. We wish to proceed with the motions.
Yes, Mr. Menka.
My Lord, I'm ready.
Ms. Oko, have you been served with the Mr. Omenka's counter affidavit?
Yes, my Lord, we have been served.
Okay. Ms. Oko, this your application. I don't.
My Lord. May I proceed, sir?
I'm just trying to say that this application, do you think it will see, do you think it will see the light of the day?
Yes, my Lord. If my Lord hear me out, I believe it will see the light of the day.
No, it's a clear issue because the parties have already closed their case and the matter, they have adopted the written address and the matter was adjourned for judgment.
Yes,
only
sir.
Only for the claimant to come and now say that his original documents that he didn't tender, he's now bringing those originals for the court to substitute them with because can you tender documents by way of motion?
My Lord, it's not tendering of documents. The documents are before the court already, sir.
How will the court know that the ones that you're presenting are the ones that have already been admitted in evidence?
My Lord, the originals have contained the content which is already before the court, sir, and admitted as evidence. The basis of this application, sir, it is the fact that the court has admitted the documents in evidence. It's not retendering. If it was retendering,
if it were, replacement of the originals with the photocopies, that's understood. That's understand. I say if it's you're applying to replace the originals with the photocopies, that's understandable. That's understandable. But after the photocopies have been admitted in evidence, for somebody to now come and apply to replace them with that takes it's not just something that should be granted. It has to be through an oral evidence of the witness.
My Lord, if it is through an oral evidence, my Lord, it would mean that the court is, the contents of the documents are not before the court, and that it would mean that the judgment of the court would be affected if it was tendered. So it is not tendering because it is.
You see, Mr. Oko, these documents have already been admitted in evidence by the court. The photocopies.
Yes. Yes.
So you are not bringing an application to replace those documents. Those documents that are in the court custody, they are court documents now. You understand? They are course documents. You want to replace them with some other documents, you know, emanating from you now. Those photocopies are
not some other.
No, you see, Mr. Oko, the other party has to be given opportunity to go through all the documents, all of them.
My Lord, they have been given the opportunity, sir.
No. Please, we tender documents through witnesses. This is a case commenced by way of pleadings, isn't it? It's not a case commenced by originating summons or originating motion. You know, when you are tendering the photocopies of those documents, they are tendered through a witness. So if you are bringing if you are bringing another set of documents to replace those already admitted, I think it has to be true, you know, an oral evidence. Not just because
that is why we brought an alternative relief. My Lord can just say, or due to the circumstances of the case, the originals which were not nowhere to be found as at the time of the trial. The court can just say, okay, I have seen the original. I have cited the original.
No, that should have been said at the point of the tender of the documents. That should have been.
The background was laid. The background was laid at the time of tendering the documents that the originals were nowhere.
Okay, since you know the foundation has been laid and the documents have been admitted, then why are you bringing this application?
My Lord, in the final written address, we don't want to be guilty of
since you know that the necessary foundation has been laid and the documents have been admitted by the court in evidence, then why are you bringing the application again?
My Lord, the final written address of the rest of the defendants have raised an issue which the court have laid to rest by giving an order that the documents are admitted in evidence. Ordinarily, they were supposed to go on appeal, but they didn't go on appeal, but they brought it. It's not like even a slap on the face of the court that the court ruled that the documents have been admitted.
What you should do in your written address is to say that the court is functions official as far as the issue of the administration of documents is concerned. But you can, there must be an end to litigation.
My Lord, it's not really litigation.
You are litigating, you are litigating because the documents have already been admitted by the court. As far as we are concerned,
Lord, even if the judgment is delivered, the court still, if there are new, even on appeal, the court still take new evidence that still surface after the trial have ended. And in this case, my Lord, it's not even as bad as that.
Yes, you can bring additional evidence on appeal, but in this case, you understand? Yes. Can you tender documents by way of filing a motion?
My Lord, we are not tendering, sir. We are not tendering.
Okay, if you are not tendering, what are you doing?
My Lord, what we are seeking to do is the documents that have already been tendered, my Lord, that the originals are existing and they have been found after the trial.
Then that thing has to be done via a witness. You understand? Via a witness. It can't just be done by affidavit evidence. You know, it's the witness that came and said, you know, that the originals are either lost or she doesn't know, you know, the whereabouts of the originals. So when they are now discovered, it should be that same oral evidence that testified before that will come and now say, I have now discovered those documents and I wish to tender them. But you can't just file an application.
To be reopening the case, sir.
Yes, now even this application is another way of Even this application is another way of opening the case because you are arresting the judgment.
My lord, it's just to say, my lord,
it's not
that
just
this document exists. My lord can just say, I have seen the originals, the photocopies have been approved.
No, I don't think that is proper. I don't think that is proper.
Under the inherent jurisdiction of the court, so the Supreme Court have held that matters that are before the court, that the court can make any orders as to any issue that arise in the course of the proceedings. And the court is vested with the jurisdiction, the inherent jurisdiction, to make any orders. They are not foreseen.
What I will advise you to do is to just leave this issue of the of the documents. When any of you goes on appeal and the matter is raised, maybe you can decide to file the the additional evidence there.
As a court, please.
Yes, but by this stage, I don't think I have already invoked our section 12 of the National Industrial Code to admit the documents. So why are you now?
As the court, please, we are most guided by the court, sir. We are learning every day, sir. Even when we are confused about a situation, we can also seek direction from the court. So, my lord, I will take this as a direction from.
If you really want to close that gap, maybe you can say, okay, let me recall my witness. Let him come and say yes. The documents that have earlier been said that they are lost are now discovered. So I can identify the originals. These are the originals. I won't tender them and replace them. That one, I think. But at this stage, because if we begin to do this, it means any party can at any time after the some documents have been admitted in evidence or rejected, he cannot bring an application to say that, okay, since the photocopies of the document have been rejected, I'm now filing a motion to replace them with the original copies. It doesn't sound. It doesn't sound.
Yes, my lord, we will be guided by the court, sir. But my lord, even if it is to present it through a witness, we can still do that, my lord, even now.
Is the witness in court?
My lord?
Is the witness in court?
My lord, I am the substituted person, sir.
Okay, yeah.
I am the daughter of the claimant who was substituted.
Okay.
I can tender if my lord will oblige. I can do that now.
No.
Mr. Amenka, what do you say?
My lord, it is not possible, my lord. It is not possible, my lord. Let us have the judgment. Whoever is not satisfied can go on appeal. These documents are ready before the court. That is my take. And by rules, all applications to court
yes, Mr. Oko.
are by motion.
Mr. Oko.
Yes, sir.
I think the defendants have even admitted some of the documents, isn't it?
Yes, sir.
Have they done that?
The documents that are before the court, there is no evidence, there is no contradictory evidence from
what I'm saying is that, is there any admission made by the defendant in their pleadings or evidence with regards to the content of the documents?
The defendants were alleging that the documents were obtained by fraud. They say they call it a kangaroo. They call especially as BCI1, they called it a kangaroo appointment.
Which one is XBC1?
SBCI1 is the letter of first appointment of the claimant.
Okay, see the blue one. See the blue one. Okay.
Yes, sir. CIY1.
Okay, CI1, yes.
Yes, sir. And they said that it is they were not going to certify it because they don't have it in their file. And the claimant has it issued by the defendants. And there are other documentary evidence emanating from the defendants that is giving credence and admitting the fact that the claimant's letter of first appointment is authentic before the court.
Okay, there are some evidence given by the defendant admitting that.
Yeah, there are evidence that were issued to the claimant by the defendants, which alluded to the case of the claimant.
No, I mean of the fact that the claimant was appointed in 1977, was given appointment letter in 1977.
Yes, sir.
Because
yes,
even
sir.
if you are tendering, Mr. Oko,
yes,
I think
sir.
you have to file a deposition, isn't it?
Yes, sir. My lord?
I say even if you are tendering the document, you have to file a deposition, isn't it?
No, well, if I'm tendering an oral evidence, there is no need for deposition again, sir. I can even apply orally.
Apply orally to, no, I mean, apply orally to do what?
To recall a witness to tender the document.
Yes, you can apply orally to recall a witness, but can you give oral evidence without any witness deposition?
Yes, sir. My lord, there is no evidence. My lord, the evidence before the court is the content of the documents. And so there is no additional evidence that is coming in. Otherwise, it will overreach the defendants. There is nothing else but than to just come and say, these are the documents that were already tendered and admitted, and the originals have been found. We are bringing the originals before the court. That is all, sir. There is no other evidence that we are going to give in this matter. The case has been closed.
Okay. That thing that you are going to say, to come and say that the originals have been found and I wish to tender, is that not evidence?
My lord, that is not evidence. It is just bringing before the court originals of documents which the claimant had already informed the court that they were nowhere to be found.
Okay.
And notice had been given to the defendants to produce these originals, which they refused because they were hostile to the claimant. They didn't want the claimant to succeed in the case. So they were hostile to the claimant on all fronts. They refused to produce the original. And that was why.
Okay, let me ask this question. Can you tender them from the bar, being public documents?
My lord, they are. I'm not tendering from the bar. My lord,
no, I'm asking
imaginary witness box.
Mr. Oko, since they are public documents, can you tender them from the bar?
My lord, I'm not going to tender from the bar. We remove my wig and gown. I will remove my wig and gown and tender as a witness.
No. Listen to my question first. Being public documents, can you tender them from the bar?
My lord, in these circumstances, yes, we can, because the documents are already before the court.
Yeah, and they are public documents, isn't it?
Yes, sir, and they are originals.
Yes, even though they're not certified, but they are public documents which can be tendered from the bar.
Yes, sir.
Okay, Mr. Amenka. DCL.
My lord, is not possible.
No, why is it not? Yes.
That we have procedures. This
Yes.
matter has been concluded.
Yes.
We have the documents we argued and admitted, and it's for judgment.
Yes, but
So
they are now making application to respond their case and tender the originals of those, you know, of those documents. Can they tender them?
It is not at this stage. They cannot tender them from the bar.
Why?
And if they want to tender now, we have the right to cross-examine them on this document. So
yes,
it's
yes,
not
yes.
possible if whatever it is an evidence they are going to give, which is not possible now, my lord.
To cross-examine them and say what? Mr. Oko,
My lord,
Mr. To cross-examine them and say what?
My lord, it is our duty. If they are giving evidence, we have the right to cross-examine them.
It's not
because
evidence.
whatever is doing now, whether I have seen this document is a new is a document that I thought is an evidence before the court, and we have the right to respond. And I don't think it is now at this point in time where we'll talk about substituting, do a substitute, and this document, the one that is before the court has been admitted. We have argued this is, and the court has admitted the one that is available. So I don't know how we want to go round and round all over again.
My lord, the court is the court of equity.
Listen, Mr. Oko, listen. Mr. Oko, can you hear me?
Yes, sir.
In your pleadings, you have given them notice to produce the original copies.
Yes, sir.
And they failed.
Yes, sir.
You know, which enable you to tender the ones that you have.
Yes, sir.
And the court admitted the document that you've tendered.
Yes, sir.
So is there any problem with that?
No, sir. No, sir.
So since there's no problem, why should we entertain this application again? Why not just withdraw it so that, isn't it?
Yes, my lord. We will rely on the direction of the court. If my lord thinks that it is not necessary, we accept it, my lord. We didn't bring it. We brought it before the court for determination. So we are also confused as to the right direction to take, because this issue have not arisen in any court before, that a document was tendered and admitted, and then subsequently the originals were found. These were things that have not happened in law before. So we're just trying to find to bring them through the window of equity, so that the court can just know that these documents actually exist. The original actually exists.
My concern is that even if those documents are admitted in evidence by of this application of yours, it may give room for the defendants to have a ground to attack the proceedings.
Yes,
because the application sounds strange to me, because after documents have been, if to the fact that you applied to reopen your case and recall your witness and tender them through that, that one is clear to me. Because even at the stage of after the adoption of final written address, parties can still reopen their case to call witnesses. But for one to just file an application and ask the court to substitute the ones that are photocopied with the ones that are, I think oral evidence needs to be called to say that.
As a
that's just my thought. But since they have been admitted by the court has invoked this section 12 of the National Industrial Code Act to admit them. Just allow the case to proceed so that isn't it?
As the court pleases.
I didn't even know that you are the daughter.
My lord, I am the one. I happen to be the one, sir. And
okay,
I have first-hand information about all that has happened to the deceased claimant, which I have also been involved in going to the defendants to appeal on her behalf.
Okay. Maybe what we'll do, because I'm not really comfortable about the application. You can withdraw it, then I will just adjourn to Monday to enable me reflect this today's proceedings in the judgment.
As
So I'll just deliver my judgment on Monday.
As the court pleases.
Yes.
My Lord, we are guided, sir. We are learning every day, sir.
Because I think if the claimant wanted to bring this kind of application, so it has to be by oral. I mean, the claimant has to call oral evidence to tender or replace the photocopies of the original. That's just my.
That is why I was saying if my Lord is comfortable with it that way, I can still remove my wig and gown and enter the witness box and tender same.
But Mr. Omenka is objecting. It's not comfortable with that.
Objection has no legal basis because the law, the court is not functus of issue until judgment has been delivered. And even when judgment is delivered, the trial court still has the powers to review his judgment when there is a new evidence that did not exist at the time of the trial. And so the objection of the defendant is baseless.
After judgment has been delivered.
Even after judgment has been delivered, sir.
Okay, the court can review his judgment.
Yes, the court has the powers.
By admitting fresh evidence, by accepting fresh evidence.
Yes, fresh evidence, sir. Yes, sir. And so long as the defendants have the right to cross-examine that witness on the new evidence that surface. Even it can be done at the trial court and even at the appellate court. A witness can still be called to tender new evidence, to testify to new evidence. Yes, sir.
After judgment is delivered.
Yes, sir. Even after judgment is delivered, sir.
The trial court has the right to review his judgment by accepting fresh evidence.
Yes, sir.
It's not possible.
So what will you do with judgment? It will now set aside the judgment or what?
It will review its judgment.
How?
The judicial authorities to that effect.
No, Ms. Oko, you are misconceiving the issue. There are instances that the court can set aside its decisions.
Yes, sir.
Or decision. That when the decision is senility, the decision is senility is given not a merit, in default of appearance or default, but when judgment is given by the court a merit. The only thing is is for any aggrieved party to go on appeal. But the court can't on issue of fact, unless if fraud is established, you understand?
Yes,
there's fraud, judgment is given in default. The judgment was senility or given per inquiry, but when judgment is court has given judgment, it becomes functions of issue. In any case, to save time, let's just withdraw this application. So I'll join the case, the matter to Monday for judgment.
As the court pleases.
Yes. Isn't it? So that we'll make progress.
May I apply to withdraw the application filed on the 13th of June, 2025. My Lord, there is a second relief that was sought there.
Yes.
to delete a word that was added to statement on oath. My lord, the word amended ought not to appear there. My lord, that deleting of the word there is not deleting of the statement on oath, sir. Deleting of the word amended.
But Ms. Okoro, does that matter?
Yes, my matter to us.
Ms. Okoro, nobody raised that issue. Nobody raised that issue. The claimant amended her pleadings, isn't it?
Yes, sir.
She filed a new deposition.
Yes, sir.
She adopted the deposition.
Yes, sir.
So why should you now ask the court to delete just because in the deposition the word amended is there, that the court should can somebody amend his deposition?
My lord, it can be amended. It's just that it's an anomaly to attach it to statement on oath. It is there in the statement of claim, amended statement of claim. We don't have any problem with that. But the typist added amended to the statement on oath. That is what we discovered and we wanted to delete.
I don't think that is necessary, please.
As the court pleases.
Yes.
As the court pleases, sir. We apply to withdraw the motion, sir.
Okay, Mr. Omenka, any objection?
No objection, sir, my lord. We are withdrawing our counterfeit affidavit as well.
Okay. So, Ms. Oko, the motion is filed on the what? 13th of June?
13th.
On the 13th of June, sir.
And dated when?
And dated the 5th of June.
Okay. So it's Monday, okay, Monday by 2 p.m.
Monday.
Yes, is that okay?
Yes, my lord. 2 p.m. is convenient.
Mr. Amenka?
It's convenient, my lord. I would have finished from court by then.
Eh?
I would have finished from court by then. The 2 p.m. is okay, my lord.
Okay, thank you.
Yes, my lord.
So Monday will be 23, ba?
Yes, my lord.
Yes, my lord.
So claimant's application to arrest judgments dated 5th June 2025, but filed on the 13th of June 2025, having been withdrawn, is hereby struck out. Meanwhile, cases are sent to the 23 of June 2025 for judgment at 2 p.m. via Zoom.
As the court pleases. Don't oblige.
Oh.
Oh, no. Yes, the second case.
My Lord, may I with leave of court exit the bar?
Thank you. Khalid, thank you.
Yes, sir.
Thank you.
My Lord, may I request for the leave of the Honorable Court to exit, my Lord.
You want to follow suit? You can go. Thank you.
Thank you, my Lord.
Thank you. Hey, Mr. Okon, where is the council? Mr. Okon. Mr. Anyao.
Yes, my lord. Good afternoon, sir.
Good afternoon. The counsel for the defendants are not in court.
My Lord, I've not seen them.
Okay, it's no judgment. We can do without them, isn't it?
Yes, sir. Yes, sir.
Yes.
They can. So, are parties present?
I won't come out.
Eh?
My lord, the claimant is not present, sir.
So also the defendants.
So also the defendant, sir.
So it's Chidima. Okay, sorry. It's not Chidima or Anyao. It's
I am, sir.
Oh, Anyao.
Yes, sir.
Oh, Anyao.
Yes, sir.
For the claimant. So this is my judgment. The claimant by of a general complaints and other accompanying processes dated 28 November 2022, but filed on 30th November 2022, commend this suit against the defendant seeking the following reliefs. Number one, a declaration that the first defendant, who is not the employer of the claimant, does not have the power to dismiss him. Number two, a declaration that the claimant, who is an employee of the second defendant, was wrongfully dismissed by the first defendant as a tacit consent of the second defendant. Number three, an order mandating the refund of the sum of $7,950 paid to the claimant by Thom Oil and Gas Limited and unjustly taken from the claimant by the first and second defendant HR department. Basic salary of 1.3 million naira per month from October 2020 to December 2020. Consolidated salary of 16,757,000 per annum at 1.3 million naira from January 2021 to judgment is delivered. Number 6, leave allowance of 1.6 million naira per annum from January 2021 to judgment is delivered. 13-month Turkey allowance of 1.3 million naira per month from January 2021 to judgment is delivered. 274,000 naira per month RSA contribution, the mandatory pension fund contribution from my salary to my retirement savings account by my employer from January 2021 to judgment delivered. 500 million naira damage jointly and severally against both defendants for A, discrimination, B, unlawful termination of employment. The defendant responded by filing the joint statement of defense and other accompanying processes on 5th June 2023, having obtained leave to deem the said process as properly filed and served. Meanwhile, a reply to the defendant's statement of defense was filed by the claimant on 9th June 2023. It is the claimant's case that he first worked for the second defendant as a contractor/consultant and was then given temporary appointment and later offered permanent appointment by the same second defendant. But after his employment, he was seconded/posted by the second defendant to help man his sister company's offshore production vessels, first defendant vessels, where he rendered technical services to the first defendant on behalf of the second defendant. The first defendant also had staff from various companies on that production vessel, engaging different services to the first defendant on behalf of the respective employers. Claimant stated that he had a staff identity card issued to him by the second defendant and all his salaries were paid by the second defendant. Claimant averred that he had no employment contract or any other formal relationship with the first defendant, but was only on their vessels for as long as his employer, second defendant, had him posted there. Claimant further about that while the first defendant vessel at sea, he did a side job and extracurricular tank clean job for Thom Oil and Gas Limited and was paid $7,950 by that company. That pipped by this payment and other matters, first defendant issued him a query which he answered out of courtesy. Claimant stated that dissatisfied with his response, and instead of sending him back to his parent company for appropriate disciplinary action, the first defendant unilaterally set up a disciplinary committee on board their vessel that purportedly tried the claimant and issued a disciplinary committee report dated 7 September 2022. Claimant averred that the committee did not reach a consensus decision, as 2 out of the 4 committee members refused to sign the disciplinary committee report, disagreeing with the outcome. That in spite of this statement, claimant was nonetheless sent off the first defendant vessel on suspension without pay and forced to refund the sum of $7,950 he was paid by Thom Oil and Gas Company Limited. Claimant stated that almost immediately after the first defendant set up another disciplinary committee comprising the 2 members of the first committee that found him guilty, an additional 2 people to further investigate the claimant. This second disciplinary committee authored another disciplinary committee report dated 13 November 2022, recommending dismissal of the claimant. Acting on this report, the first defendant purportedly terminated the claimant's appointment, while the second defendant, who is the claimant employer and who has been the one paying the claimant's salaries, immediately cut off his salary payments and RSA remittances till date, hence this suit. The first defendant assumed an authority they did not have over the claimant, and fired the claimant from the second defendant employment. Claimant about that the second defendant, which is the claimant employer, has not issued him any query, taking any disciplinary action against him, formally terminated his appointment in line with his employment contract or the requirements of the law. The defendant's case is, however, that the first defendant, through the second defendant, retained the service of the claimant as a deputy company appointed representative in 2015. That the claimant's role as a deputy company appointed representative was to act in the first defendant representative on board its floating storage and offload facility, and supervise the contractors engaged by the defendant to carry out services for the first defendant. That in complete violation of the employment contract and policy of conflict of interest entered between the claimant and the defendant, as well as the defendant's employee handbook, the claimant engaged in a tank cleaning exercise being carried out by a contractor of the first defendant, which he was assigned to supervise as a deputy company appointed representative, and even collected remuneration from the contractors. Further about that, upon the claimant being issued with a query and the receipt of his non-satisfactory response to same, the defendant, in line with the claimant's employment contract and the defendant employee handbook, set up a panel of inquiry to investigate the allegation level against the claimant. But the panel consisted of 4 management staff of the first and second defendants. The defendant continued that after according the claimant fair hearing, wherein he considered to have contravened the first defendant policy on conflict of interest and his employment contract by his actions, the defendant reached a conclusion that the claimant be placed on suspension without pay for 2.5 months and refund the remuneration received from the contractor. That while the claimant was under suspension, another allegation was leveled against him by the manager of the first and second defendant for unduly soliciting for compensation and extortion of member staff of the vendor. Consequently, a second disciplinary committee consisting of management staff of the first and second defendant was set up to investigate the allegation level against the claimant. That when given an opportunity, the claimant could not defend the allegation level against him, but rather pleaded for clemency and forgiveness. Defendant also about that at the conclusion of hearing, the first and second defendant reached the conclusion that given the nature of the action carried out by the claimant, which amounted to gross misconduct, the employment of the claimant was to be terminated in line with his contract of employment and the first and second defendant's employee handbook. At line with the actual DPR guidelines for the release of staff in the Nigerian oil and gas industry in 2019, the DPR was informed of the undue action of the claimant and the decision of the defendant to terminate his employment. That the employment of the claimant was duly terminated by the first and second defendant on the 20th day of November 2020. At the trial, which commenced de novo on the 7th day of May 2024, claimants testify as CW1. He adopted his witness statement on all dated 28/11/2022 and 9th June 2023 as his oral evidence in chief. Claimant also tendered his documents, which were marked and admitted as Exhibit C1 to C14, CW1 to CW14. Claimant was cross-examined by the defendant counsel and consequently closed his case. On 23rd of October 2024, defendants opened their defense by calling their witness. Mr. Benjamin, the human resources manager of the first and second defendant, was laid in evidence as DW1. 10 documents were tendered through him and marked and limited in evidence as Exhibit DW1 to DW10. DW1 was cross-examined by the claimant's counsel on the 19th of November 2024 and was subsequently discharged. Defendants also called Ms. Rashida Saleh, DW2, the head of human resources of the first and second defendant on the 4th of February 2025. DW2 was led in evidence in chief, and 10 documents were tendered through her, which were marked and remitted in evidence as exhibits. DW21 A to D to DW210 A and B. DW2 was thereafter cross-examined by the Claimant's Counsel and was subsequently discharged, and the defendants thereafter closed their case. The matter was then adjourned for adoption of final written addresses. Defendant filed their final written addresses on the 25th of February 2022. Meanwhile, the claimant filed his final written address on 4th 2025. A reply on points of law was also filed by the defendant on the 17th March 2025. Defendant final written address. Defendant final written address was franked by OO Anyau ESQ, wherein a sole issue for termination was formulated by counsel to it. Whether given the fact of this case, the evidence before the court and the applicable law, the claimant is entitled to the relief sought in the complaint. Defendant counsel argued in the negative and addressed the court on the 3 allegations upon which the case of the claimant rests to it. Number 1, allegation that the claimant was employed by the second defendant and duly terminated by the first defendant who was not his employer. Number 2, allegation that termination of the claimant's employment was not in consonance with the terms of his employment and due process. Number 3, allegation that the termination of the claimant's employment was done in violation of the 2019 DPR guidelines for the release of staff in Nigeria oil and gas industry. Counsel submitted that the first allegation of the claimant exists only in the imagination of the claimant, and same is not supported by the hard facts and evidence before this court, and as such is bound to fail. Counsel relied on the case of Omishore and Arebeshola and submitted that the burden of proving a fact rests on a party who asserts the affirmative of the issue and not on the party who denies it. Section 131 of the Evidence Act was also referred to. Counsel stated that the claimant has alleged in his pleading that he was employed by the second defendant, but the said employment was terminated by the first defendant without supporting the allegation with credible, undisputed fact and evidence. Just submitted that none of the documentary evidence tendered by the claimant support the allegation that the claimant was employed by the second defendant, but terminated by the first defendant. Rather, the majority of the documents support the contrary. That the defendant whom the burden of proof does not rest have put out credible evidence to support the fact that the claimant was not only disciplined by the second defendant, but indeed his employment contract was terminated by the second defendant. Counsel contended that the claimant in his pleadings admitted that the first and second defendant are sister companies that is administered by the same management team, but turns around to say that they are distinctly incorporated entities. Counsel thus stated that it was the intention of the promoter and shareholder of the first and second defendant to incorporate 2 separate companies, and that cannot take away the fact that the intention of the promoter and shareholder of the first and second defendant was to set up the second defendant as a sister company to provide human resource services to her. That both defendants worked in conjunction in the employment, welfare, discipline, and termination of the claimant. Counsel argued that this fact is clear and established without a shred of doubt by the facts and evidence before this court. Counsel pointed out to the fact that the employment letter offered to the claimant by DW2 in a capacity as head of human resources for the first and second defendant clearly stated that the second defendant is a subsidiary of the first defendant. Counsel referred to the last paragraph of the employment contract and further submitted that DW1 and 2, which are the employment letter and pay slip of DW1, prove that although DW1 was employed by the second defendant and paid by the second defendant, he works for both the first and second defendant as the manager of human resources. That shows the fact that the second defendant recruits and pays personnel, including the claimant on behalf of the first defendant. That exhibit DW1, 6, and 10 are staff identification IDs issued by the second defendant and the first defendant respectively to DW1, which establishes the fact that all staff employed by the second defendant on behalf of the first defendant were initially issued ID by the second defendant. That is, with DW2 are also incorporated documents of the defendant which establish without shade of doubt that both defendants have principally the same promoters, shareholders, and directors. Exhibit DW1, 3 and 4, 3, 4, and 5, and DW2, 2, 3, 4, and 5 are correspondences relating to discipline, welfare, duties, and obligation of the claimant, which also establish the fact that the defendants were jointly responsible for the claimant. That the entire disciplinary process, which was carried out by the defendant, which led to the eventual termination of the claimant's appointment, were carried out by the officers of the first and second defendant in their capacity as management staff, members of the first and second defendant, as seen in Exhibit CW13. Relying on the case of Mogaji, and Odifin, counsel submitted that the law is settled that in civil proceedings, the standard of proof is based on the preponderance and balance of probabilities. The totality of the evidence of both parties is to be taken into account and appraised to determine which evidence has weight and which has none. Therefore, the contention of the claimant that he was employed by the second defendant but was terminated by the first defendant is baseless, unfounded, and not supported by the fact and evidence before the court. On the second allegation that the termination of the claimant's employment was not in line with the terms of his employment and due process, counsel argues that in civil proceedings, the defendants did not admit the claimant's claim. The burden, where the defendant did not admit the claimant's claim, the burden of proof lies on the initiator of the suit, who will still lose if no evidence is adduced. The above principle of law applies to suit burden to wrongful termination of employment, set in the case of CAT2 and CBN. Counsel submitted that in the case of NDLA and Zachary, it was said that an employee who complained that his appointment was wrongfully terminated has the honors to place before the court the terms and conditions of the contract of employment and prove the way and manner those terms were breached by the employer. That a critical review of the fact in support of the claimant's case and the evidence laid in support of same will reveal that although the claimant has made spurious allegation that his contract was unlawfully and unduly terminated by the defendant, he has failed to produce the terms and conditions in the defendant's employee handbook and outline specific provisions contained therein and how same has been breached by the defendant in the course of termination of his contract. Counsel maintained that the first and second defendant are sister companies and all the actions taken by the second defendant are done on behalf of the first defendant and vice versa. That he who has to hire also has the authority to terminate said employment. Claimant was hired by DW1 in a capacity as head of human resources of the first and second defendant, and his employment was terminated by DW1 in a capacity as head of human resources of the first and second defendant. thorough allegation that the termination of the claimant's employment was done in violation of the DPR guidelines. Counsel argued that it is settled law that when a party standing to sue is an issue, the question is whether the person who is standing is an issue is a proper party to request an adjudication of the particular issue, and not whether the issue itself is justifiable. Counsel started the case of AG Federation and AG Lagos State. Counsel contended the Nigerian Upstream Regulatory Commission, formerly called the DPR, is the sole legal entity with the legal right to enforce the provisions of the DPR guidelines for the release of staff in the oil and gas industry, and not the claimant or any other person. Counsel placed reliance on the Court of Appeal case of Osagolum and INEC. Counsel pointed out that in case of its breach, the said guidelines provides for the sanction, which is limited to the penalty being paid to the Nigerian Upstream Regulatory Commission. And the said sanction does not in any way contemplate the relief sought by the claimant. That the guidelines itself is a privy to a contract that exists between the Nigerian Upstream Regulatory Commission and the first defendant. That a proper procedure exists for a claimant who believes that the termination of his employment was done contrary to the said guidelines, which is for the claimant to write a petition to the DPR alleging that the termination of his employment was not carried out in line with the terms of his employment, rather than taking out a complaint against the defendant. Counsel also contended that, assuming without considering that the claimant has the standing to enforce the provision of the guidelines, the provision of the guidelines do not inure in favor of the claimant, given the fact that termination of his contract was carried out on the 25th of November 2020 before the advent of the PIA 2021. That where a cause of action occurred before the advent of an alteration of the law governing the same, the applicable law is the one which was in operation at the time the cause of action arose. Setting the case of SPDC and Anaro and Aremo and Adekanya, counsel continued that the termination of the claimant's contract was carried out on the 25th day of November 2020, at which time the applicable regulation as regards the issue, the guidelines for the release of staff in the oil and gas industry 2019 made pursuant to Section 9 of the Petroleum Act 2004. Relying on the case of Pengerson and Chevron, delivered by Honorable Justice Oji, and NNPC and Fampa Oil Limited, counsel emphasized that the claimant's cause of action, having arisen before the advent of the PIA 2021, provisions of the 2019 guidelines for the release of staff in oil and gas industry do not inure in favor of the claimant. Counsel therefore urged the court to so hold. Claimant's final written address. Claimant's final written address was franked by O. Anyawu ESQ, wherein counsel formulated one issue for termination 2 weeks. Well, the claimant has established his claim to be entitled to the relief sought. Counsel submitted that in an action seeking declaration and the termination of one employment, counsel submitted that in an action seeking declaration that the termination of an employment is illegal or wrongful and nullity, the claimant must plead and establish the nature of his employment, the condition of service, and circumstances under which the employment can be terminated, which show that his appointment was wrongfully terminated. Setting the case of Kato and CBN, Ibama and SPDC. Counsel asserted that the second defendant is his only employer, and to prove that, claimant has tendered his contract of employment between him and the second defendant. Exhibit CW1, his staff ID card. Exhibit CW5, his pay slip. Exhibit CW4, a letter of salary of increase from second defendant. Exhibit CW6. That Exhibit CW1 is a complete document that also contains his condition of service. It contains his schedule of duties / responsibilities to his employer, the responsibilities to him, his total enumeration package, and the mode of termination of the contract. Counsel also submitted that the contract was breached by the second defendant by its failure to comply with the procedure for termination, which required them to issue 1 month notice to the claimant before it can terminate his appointment. It submitted that there exists no previous or subsequent employment contract between the claimant and the first defendant, that they cannot add to or subtract from the content of Exhibit CW1, CW4, 5, and 6 by their testimony in court or other insinuations. Documents speak for themselves. Counsel cited the case of Honorable Amos Gombi Goel and INEC. It is contended by the operation of Section 42 of the Companies and Allied Matters Act of registration, an incorporated entity assumes a life of its own and exists separate from its individual shareholders and any other legal entity. Counsel cited the case of Fawhim and Nigerian Bar Association. Counsel continued that the first and second defendant were incorporated differently and separately, and both exist differently and separately in the eyes of the law, with distinct and separate recognition in the eyes of the law, irrespective of their common shareholders and promoters. It is a further submission of counsel that the claimant was employed by the second defendant but unlawfully fired by the first defendant, that in law, only he who hires can fire. It's only the second defendant that can fire the claimant. And the first defendant cannot do it on behalf of the second defendant or by themselves as of right. Counsel refers to the case of Yeri and Bendel Feed Flour Mill Limited. Counsel submitted that it's not the law that, as it offends the principle of separativeness of legal personality and the privity of contract between the second defendant and the claimant, and urged the court to so hold. On disciplinary action taken by the first defendant, counsel contends that the first defendant assumed powers that they do not have and went ahead to discipline a person not subject to his authority, thereby acting ultra vires, citing Ekanem and PUB. Counsel continued that the disciplinary right of an employer flows from the employment contract relationship. There have been no employer-employee relationship between the claimant and the first defendant. Any purported exercise of discipline over the claimant is void. The contention of claimant that the first defendant subjected the claimant to disciplinary procedure predicated on their own employee handbook and policy on conflict of interest, which are extraneous to his contract and condition of service and cannot form part of the claimant's contract of service to his employer. The first defendant is wrong to have relied on the first defendant employee's handbook in carrying out the two disciplinary actions against the claimant. Claimant submitted that DW1 confirmed under cross-examination that the second defendant has its own employee handbook issued to them upon their employment. His further explanation that the second defendant's own handbook was later withdrawn some years thereafter, and the first defendant's own handbook became the operational document is inadmissible in evidence, not being pleaded. Such in the case of CDC and Natural Nigeria Limited and Square Nigeria Limited. Counsel pointed out that the issue of the refund of the sum of 7,000 USD plus from the first disciplinary procedure the first defendant subjected the claimant to. Counsel stated that the procedure produced that the procedure that produced Exhibit CW14 led to issuance of Exhibit CW7 to the claimant, The claimant was directed to refund the USD. Counsel argued that the first defendant lacked the locus standi and the virus to discipline the claimant in the first place, which said disciplinary action led to the refund of the sum of 7,000 USD. There was a further contention of the claimant that he was not given fair hearing by the second defendant. As the evidence of CW1, DW1, and DW2 is that the two disciplinary procedures undertaken against the claimant were carried out by the first defendant. There is no evidence of any query issued to the claimant by the second defendant being his employer. The second defendant did not allege any breach of his duty to them, or a breach of their own employee handbook and policy manual, and they did not subject him to any disciplinary action. That they therefore acted wrongfully in cutting off the claimant's salaries and entitlement without first carrying out any disciplinary procedure against him and without affording him an opportunity to defend himself before them. Citing the case of Eliki and Nwankolo. Counsel submitted that the second defendant has not issued him with any termination letter to date, that in the eyes of the law, the contract still subsists and is still entitled to his salaries and emoluments. Just pointed out that the capacity to which DW1 was acting for the first and second defendant was very clear and unambiguous. That her actions in her capacity as the head of HR for the first defendant is distinct from when she is acting for the second defendant. That her actions for one limited liability company cannot be imputed to the other limited liability company. Submission of a council that the DPR guidelines for the release of staff in Nigerian oil and gas industry 2019 was made pursuant to Regulation 15 of the Petroleum Drilling Production Regulation 1960, which are made pursuant to Section 9 of the Petroleum Act. 2019 guidelines replace the earlier circular titled Release of Nigerian Workers from Employment in the Petroleum Industry and Utilization Expatriate Quota of 1997. Counsel submitted that the defendant fall under the definition of Regulation 15. Counsel further submitted that the paragraph 1.3 of the DPR guidelines state that the purpose of the guidelines was to establish a procedure for obtaining the consent of the Minister of Petroleum Resources through the DPR for the release of any worker employed by the holder of an oil mining lease, license or permit under the Act, or any person registered to provide any service related thereto. That paragraph 3.1 of the DPR guidelines defines staff release to mean the removal of a worker from the employment of a holder of an oil mining lease, license or permit under the Act, or any regulation made thereunder, or any person registered to provide any service relating thereto in a manner resulting in the permanent separation or severance of the workers from the company. Counsel maintains that assuming the first defendant had power to fire the claimant, they did not comply with the guidelines because they sent an application dated 10th November 2020 to the DPR asking leave to terminate the claimant. That application was received by the DPR on the 16th of November per the acknowledgement stamp on the face of it. Counsel contended that they did not wait for the approval of the DPR and went to issue Exhibit CW8. In other words, they did not obtain consent as required by the guidelines. And this infraction of the guidelines renders the termination unlawful. Counsel urged the court to find that the claimant has established every single head of his claim to be entitled to judgment. Defendants reply on points of law. Defendant reply on points of law is dated and filed on 17th March 2025, where it was argued that when more than a single document provides the terms of a contract, all documents must be construed jointly. Council rely on the case of Ladipo and Chevron Nigeria Limited. On the claimant's contention that he was not afforded fair hearing by the second defendant, and the entire disciplinary process leading to his termination was carried out by the first defendant, counsel reaffirmed that not only was the claimant afforded an opportunity to be heard, he was in fact heard. That the claimant who had been afforded fair hearing by the defendant but failed to defend his actions cannot revert to a false cry of failure to be afforded fair hearing. Counsel started the case of Deu Nigeria Limited and Alamile. On the claimant's submission that the defendant did not comply with the DPR regulation for the release of staff in the oil and gas industry, rendering the termination of the claimant unlawful, it is the contention of the counsel that the claimant's cause of action having arisen before the advent of the PIA 2021 said the DPR guidelines cannot be applied in the resolution of the fact of the case and do not inure in favor of the claimant given the facts of this case and the applicable law. Counsel rely on the case of Ozobeme and Total E&P Limited. Decision of the court. I've carefully studied the pleadings of the parties and the evidence adduced. I've also read a submission of the respective counsel for the parties and the issue for termination. And the issue for termination I will deal with is, and I quote, whether the claimant is entitled to the reliefs sought. From the pleadings and evidence presented by the claimant, it was stated that the claimant worked as a contractor consultant for the second defendant and later received temporary and permanent appointment. That he was seconded to work for the second defendant but had his employment terminated by the first defendant. That the claimant disputed the termination, arguing that the first defendant lacks legal standing to terminate his employment since his contractual relationship over the second defendant. Claimants also alleged non-compliance with the DPR guidelines for the release of staff in oil and gas industry, rendering the termination unlawful. To stress that the burden and standard of proof in civil cases is on the party who asserts to prove his case on the balance of probability and preponderance of evidence. See sections 131 and 134 of the Evidence Act and the case of Amos and Photo Palace. Principle of law as well established in Nigerian jurisprudence is that to succeed in a claim for wrongful termination or dismissal, claimant bears the burden of proof to establish by credible evidence the terms and conditions of contract of employment and must demonstrate how the defendant breached these terms and conditions. See the case of Nitel PSC and Aqua. By placing the onus on the claimant to prove his case, the court ensures that the claimant provides sufficient evidence to support his allegations of wrongful termination or dismissal. Claimant seems to heavily contend that there is no contractual relationship between him and the first defendant, emphasizing that he was hired by the second defendant and has no employment history with the first defendant. However, the defendants claim that the first defendant established the second defendant to provide human resources for his oil production facilities. They argue that it is their operational policy for the second defendant to employ staff on behalf of the first defendant, with the first defendant covering salaries and emolument through the second defendant. Court of Appeal in Coast Oil and Tuboscope Betco International Company reaffirmed principle of privity of contract, which holds that only parties to a contract can enforce its terms or to be bound by its obligation. A non-party cannot claim rights or liabilities under such a contract. This doctrine is well established in our law as seen in Vital Investment and Capital PLC. However, exceptions exist, including covenant concerning land, agency relationship, and assignment. C. Mbata and Amanzi. National Industrial Court, under Section 254C and of the Constitution, is empowered to apply international convention on best practices in labor dispute. This aligns with the International Labor Organization's stance on adapting labor standards to evolving workplace dynamics, particularly where employers use subcontracting or outsourcing to circumvent labor conventions. Even before the Third Alteration Act, Nigerian court recognized exception to privity in employment context. In Onu, Malobi, and NNPC, the Court of Appeal upheld the concept of co-employer status, rejecting strict privity rule, where a parent and subsidiary company jointly control an employee. This was reinforced by Shena Security Company Limited and Afropac Nigeria Limited. The NISCN under Order 14, Rule 1 of its rules, can enforce international treaties like LIO Convention on Private Employment Agencies, which recognizes triangular employment relationship involving agencies, workers, and end users. The accompanying recommendation further supports tripartite engagement in labor governance. Section 10 of the Labor Act anticipates such arrangement by defending an employer broadly to include those who engage workers for their own service or another's. This statutory recognition validates co-employment, though its existence depends on factual circumstances. See Diamond Bank and Nubifi. Claimant in the instance case was employed by the second defendant on 16 November 2015, and the second defendant seconded him to the first defendant as his deputy company appointed representative. Aside the above fact of the claimant, it is also evident that although the appointment of the claimant was issued on the letterhead of the second defendant, paragraph 2 of CW1 says, and I quote, Oriental O&M Services Limited is a subsidiary of Oriental Energy Resources Limited, and you may at any time be asked to work within any other unit of the company during the period of your employment. This appointment will be subject to the terms of the enclosed contract and time spent in the service of any other group's department or affiliated companies will be taken into consideration when calculating cumulative length of service. It's clear from Exhibit 1 that the second defendant is a subsidiary of the first defendant, which means subject to the control of the first defendant. Exhibit CW3 being the consultancy service agreement the claimant entered with the second defendant in September 2015 is clearly headed at the top right corner, and I quote, Oriental Energy Resources Limited. And the head human resources that signed the letter of employment of the claimant is the same person that signed the letter of termination. It is the first defendant through the second defendant that is responsible for the payment of the remuneration of the claimant. The second defendant categorically put the first defendant as one who will carry out the disciplinary procedure in the Oriental Energy Resources Limited employee handbook, which was stated in paragraph 3 of the letter of employment. This has also been made clear. It is the first defendant that will handle the disciplinary procedure of the claimant. In fact, from the perusal of Exhibit DW 3, 5, and 4, 3, 4, and 5, which are correspondences relating to discipline, welfare, duties, and obligation of the claimant, it establishes the fact that first defendant controls the application of the funds given to the second defendant for the claimant and the disciplinary powers. The above fact presents an appropriate scenario where the court will adopt the principle of primacy of fact as against principle of privity of contract. It's now settled that in determining the nature of a relationship between parties in employment dispute that present this type of relationship, this honorable court is to apply the primacy of fact, which simply implies that it is the facts that determine whether a person is in a contract of employment or not, and not only not only the presentation of the contract document, but the practice of triangular employment and co-employer status has been welcomed and adopted by this court in deserving cases fine for an employee. See the case of Pengasan and Mobile Producing or Limited Company. Therefore, where a company which is a subsidiary to another is so integrated into and under the control of the parent company, the court will hold that co-employment exists and both companies will be bound by the duties and obligation in respect of the employment contract. Thus, in the case of Pengasan Supra, it was opined that the termination of the existence of an employment relationship should be guided by the fact of what was actually agreed and performed by the parties, and not just by the name the parties have given the contract. The court considered the fact of the policy under which the employee performs his responsibility, who is responsible for the payment of the employee's salaries and exercise control and disciplinary powers. It's also the case of Union Beverages and Pepsi Cola. Given the fact that the first defendant under the employment is not only responsible for the payment of salaries of the claimant, but also has the power as well as the right to terminate the contract and issue notice or pay salary in lieu of notice, this court cannot but hold that the first defendant has the power and authority to carry out the disciplinary procedure that leads to termination of the claimant's appointment in the light of the above facts. Second defendant is just a tool being used by the first defendant, as it is the first defendant who exercises employees' powers and performs employees' duties over the claimant. Currently, I'm of the opinion that both the first and second defendant are co-employees of the claimant and are so held. Having found that the first defendant had the right to terminate the employment of the claimant, being a co-employer, was the disciplinary action carried out in line with the terms of the contract? The Supreme Court in Skybank PLC and Adegun has laid down the requirement of fair hearing in the dismissal of an employee, where it held that, and I quote, despite the fact that an employer has a right to dismiss an employee, dismissal should not be wrongful. The motor questions which the court will consider in determining whether a dismissal is proper or wrongful will be, was the dismissal carried out in line with the procedure laid down in the employee's handbook or any document governing the employment relationship? Was the issue of the letter of dismissal competent to do so? Or the dismissal process carried out by a competent authority? Was the employer afforded fair hearing during the dismissal process? The employer has the duty to ensure that it does not enigmatically raise its executive stick in operation of the employee. And it's important that every employer must be careful not to abdicate or abuse its powers. It has been held that employers and public bodies are required by law at all times to act in good faith, reasonably and fairly towards people and matters under their charge in all circumstances. The law does not permit employers to act arbitrarily. The question of whether there was fair hearing during the dismissal process is so weighty that where the court finds that an employee was not afforded fair hearing, it renders the dismissal wrongful, entitling the claimant to damages. Having said that, the employer had the duty to ensure that the internal inquiry process, which was set up to hear and determine the allegations against an employee and based on which the employer was recommended for dismissal, was done within the dictates of the law. The dictates of the law as regards firing is predicated on two main points. Simply put, they are that the employee must be given opportunity to respond to the allegations against him and must have the opportunity to face his accusers. Where these have not been observed, it cannot be said that the employee was afforded fair hearing before dismissal, therefore rendering dismissal wrongful. It should also be pointed out that an employee can be given an opportunity to present a case in defense of the allegation against him orally or in writing on court. It needs to be emphasized that the importance of fairness and due process in disciplinary hearing, and the key points that need to be highlighted are that the employee must be informed of the nature of the charge against him to prepare for his defense. The employee should be given the opportunity to state his case regardless of the circumstances, and while the employee's physical presence throughout the hearing is not mandatory, he must still be given a fair chance to present his case. It's clearly shown and considered from the evidence of the parties before the court that the exhibits presented that the claimant was issued a query which he answered. Similarly, it was stated by the claimant under cross-examination as follows. Yes, I was issued a query by the defendant which I responded to on the 19th of August 2020. Yes, after my response, I was mandated to go on suspension for 2.5 months on 28th October to August 2022. While on suspension, further allegations of bribe were leveled against me. Yes, a disciplinary committee was set up to investigate the allegations of bribe, while the committee recommended for my termination on court. It's clear from the query given to the claimant, his answer given in Exhibit 7, and the reports of the disciplinary committee, Exhibit 13 and 14, that the claimant was given a hearing and was confronted with the allegations raised against him. The law is that where an employer dismissed or terminated the employment of an employee on grounds of infraction, all that the employer needs to justify his action is to show that the allegation was disclosed to the employee, that he was given a fair hearing. That's to say that the rules of natural justice were not breached, and the disciplinary panel followed the laid-down procedure, if any. It was held in Joseph and First Bank that an employee who was confronted with allegations of misconduct before his employment was terminated cannot complain about lack of fair hearing. In the light of the above, therefore, I dismiss the contention of the claimant that his termination by the defendant is wrongful for lack of fair hearing. I see nothing wrong in the act of the defendant of dismissing the claimant that constitute a breach of fair hearing or the terms and conditions of the service as contained in the defendant's employee handbook. On the ground advanced by the claimant in contending that the termination of his employment was wrongful due to non-compliance with the guidelines with the DPR guidelines, the defendant relied on Section 10 of the Petroleum Industry Act, and contended that the guidelines is a product of the privity of contract between the Nigerian Upstream Regulatory Commission and first defended by virtue of the oil mining licenses donated by the DPR to the defendant. But the DPR has exclusive right to regulate the first defendant entire operations to ensure that same is carried out in line with the Petroleum Industry Act and any regulation made under the PIA, including the regulations. The 2019 guidelines were made pursuant to Regulation 15A of the Petroleum Drilling and Production Regulations of 1969, which are made pursuant to Section 9 of the Petroleum Act of 2004, now repealed by Petroleum Industry Act of 2021, effective 16 August 2021. Regulation 15A of the Petroleum Drilling and Production Regulation 1961 provides thus, and I quote, the holder of an oil mining lease license or permit issued under the Petroleum Act or under regulations made thereunder, or any other person registered to provide services in relation thereto, shall not remove any worker from his employment except in accordance with the guidelines that may be specified from time to time by the minister. In the case of Mr. Obashogi and ADAX, Petroleum Development Limited, Michael Smith, Atoy, and Petro Fac Energy Services Limited, this court per Daily Peters J held that the DPR guidelines cannot be relied on to invalidate the termination of employment, as the guidelines are not incorporated in the contract of employment and therefore extraneous to the terms, which the parties voluntarily agreed, and the court could not import the 2015 guidelines to challenge the termination of the employment. Similarly, in Pengasan and Chevron, per OGJ and Prime 127 and Minister of Petroleum Resources, per Gwandu J, this court again held that the DPR guidelines were not validly made and ultraviolates the powers of the minister to regulate private employment contracts. However, in Shell and Minister of Petroleum Supra, per BB Kanyim, the Honorable President of the Court, it was held that the guidelines for the release of staff in Nigerian oil and gas industry can validly govern the employment relationship between the claimant and its employees, even when the said guidelines were not incorporated into the contract of employment executed by the claimant and its employees. The guidelines have legislative support in the PIA and the Interpretation Act. It was further held that the DPR guidelines, being a subsidiary legislation with legislative backing, is not only valid, but also survived the PIA 2021 and is automatically applicable without recourse to the contract of employment of the parties being a government policy. Nevertheless, in Korede, Olariwaju, and Hussein and Nigerian Egypt Oil Company Limited, and Mrs. Ozebeme and Total Exploration Production Nigeria Limited, delivered by Honorable Justice Oji on 3rd April 2025 and 2nd April 2024, this court has again ruled that the guidelines do not apply in favor of the claimant. In the light of the above, I wish to observe that having the defendant taken all the necessary procedures by giving the claimant a query and constituting a disciplinary panel and disciplining the claimant for the infraction that he has committed, the defendant do not need to wait for the approval of the DPR before they ultimately terminated the claimant. After the defendant had written an application dated 10th November 2020 to the DPR, which was received on the 16th November 2020, the defendant, however, went ahead to terminate the claimant without approval of the DPR, which up till now has not been given. The question that agitates my mind is that, will the defendant wait indefinitely for the approval of the DPR even after all necessary measures have been taken to discipline the claimant? I think not. All said, I am of the opinion that the claimant has not been able to prove his case. The case ought to fail and is accordingly dismissed. The first defendant had the power and authority to carry out disciplinary procedure that led to the termination of the claimant's employment. Termination was not wrongful, regardless of the provision of the DPR or of the provision of the guidelines for the release of staff in oil and gas industry 2019. Judgment is entered accordingly with no order as to cost.
As the court pleases. My Lord, we are very grateful for the industry the court has shown in delivering this judgment. We are very grateful, sir. Thank you very much.
Thank you, Mr. Anya. I've gotten some two recent decisions delivered by Brother George. In April this year.
Okay.
Yes, saying that the guidelines do not apply again. So
my Lord, this shall be
Yes,
I
Mr.
said my
Anyang.
law's decision now is the latest.
No,
I said my law's
in
current
April.
decision of today is the latest on the point.
So I have to follow suit.
Yes, sir.
Yes, I have to follow. Out of the about 6 judgments delivered by the judges in our court, it's only one that was delivered by the president that favors the application of the of the guidelines. Yes. Yes, in any case, that's
Yes, my lord, that of the president.
Yes.
Mm.
So yes, it's only the judgment of the president that has upheld the applicability of the DPR guidelines. In any case, that is my opinion. Yes.
As the couple is, that's what we can only say, sir. Yes, sir. We are very grateful for the industry, sir.
Thank you, Mr. Anyao. Thank you so much.
Yeah, thank you, my lord.
Thank you. In the absence of any other thing, and Mr. Okon, that will be all, ba? Okay. Thank you.
Thank you, my lord.
Thank you, Mr. Anyao. Thank you, Mr. Okon. Thank you. So that will be all for today. Wishing you good night. Thank you.
Good night, Andy.
Thank you.